Hello, everyone. This is Aaron Gelb, giving you a brief welcome before we get started. Depending on where you are in the country, either finish your lunch, start your lunch, get your coffee. So thanks again for joining us for our June OSHA webinar, preparing for and managing OSHA inspections. This is certainly one of my favorite programs to present. I think we get a lot of great feedback. We try to really share all of the collective experiences, the interesting occurrences, lessons learned from the many inspections that we manage, whether in person or remote. My colleague Ashley Mitchell, you'll hear from in a bit, was on site with OSHA just a couple days ago. I was just the week before. So we do this all the time. It's what we do. That's one of the reasons that many of you rely on and call on us from time to time. We've got a new presenter joining us today, Mark Ishu, who you'll hear from in a second, as well as my DC-based partner, Dan Deacon. So we'll start off with just some brief introductions. We'll turn our cameras on for the introductions just so you can put a face to the voice. Then we'll turn them off and we'll get started. So hello again. I'm Aaron. Nice to have you all here. I am one of the firm's managing partners. I am based in Chicago, where I lead the firm's Midwest OSHA practice. I've been representing employers in OSHA matters for coming on 3 decades now. It's still hard for me to believe that when I say it. I've been in Chicago for the majority of my career. Spent a lot of time dealing with all the area offices here in Illinois, the 3 in Chicago, the 2 mid-state and downstate. But my practice is nationwide. I have handled matters in almost every state, dealt with pretty much every state plan and the majority of area offices. So good. Again, glad to be here with you all. And I'll just kind of going down the line. Dan, I'll turn to you, then Mark, our newest addition to the firm, and then Ashley, and then we'll get started.
Great. Thanks, Aaron. I am Dan Deacon. I'm a partner based out of our Washington, D.C. office. I've been with the firm for a little over 8 years now, working in both the OSHA and the employment group. Like Aaron, my practice is nationwide, and I have a lot of experience in all the state plans and working with Fed OSHA, handling inspections, investigations, fatality and catastrophe inspections. So we're really looking forward to an interesting discussion today. And feel free to ask any questions in the chat or reach out to us at any time after the presentation today. So with that, I'll turn it over to Mark to introduce himself.
Thanks, Dan. My name is Mark Ishu. I'm a senior counsel at Conmaciel. I just joined the firm about a little over a month ago. I'm very excited to be here with this group. I've been opposing counsel at the solicitor's office for many years against Conmaciel. I worked at the solicitor's office in Chicago for 10 years, representing OSHA, as well as other agencies at the Department of Labor. My experience in OSHA is extensive, representing the solicitor's office, and now I'm getting the defense side, and I'm happy to join Aaron, Ashley, and Dan today to talk about my experiences as well. And Ashley, on to you.
Thanks, Mark. So good afternoon, everyone. I am Ashley Mitchell, and I am an associate based in our Chicago office. So I work in the office with Aaron and Mark. And as Aaron mentioned, I was actually just on site with OSHA earlier this week. And it was certainly not my first time. We like to joke that we have our go bags ready. So this is definitely one of my favorite topics to, talk about and kind of discuss. And I am looking forward to today's discussion.
Thanks, Ashley. Like I said, turn off my camera in just a second here. I know you all tune in for the knowledge, not to see our faces, although some faces probably look better than others, mine being the latter category. So with that, I will turn it off and we will get started. Now, if you've joined any of our, or quite a few, I'd say, of our webinars, we love to share statistics and with respect to the number of citations issued and number of inspections and all that. We've covered those extensively, I think, in our webinar at the beginning of the year. We'll probably cover them again as they are updated later in the year. So I just kind of cherry picked a few slides, really one statistical slide in particular, just to kind of emphasize why it is so important to prepare for inspections. As you probably know and have heard either from us or from the trade press, that OSHA is increasing the number of inspections, certainly significantly higher than during the pandemic as life returns to some semblance of normalcy. The big thing that we really are emphasizing to our friends and clients is OSHA's focus on it's really, I think, at the Department of Labor level, this concept of using all the tools available in the agency's toolbox to really drive change. And so, as we've covered in some prior webinars this year, we see new citation and enforcement policies, the expanded use of instance by instance citations, the continued increase almost year over year of repeat citations, the expansion of the SVEP program, Severe Violator Enforcement Program, making it easier for the agency to place a larger number of employers into that program. Fines go up every year, as you all know. New emphasis programs seem to be launched on a weekly, if not monthly basis. Here in Chicago, in Illinois, we're working with a number of food manufacturing clients that are subject to the food manufacturing emphasis program in Region 5. Just the other day, Region 1 announced an emphasis program for seafood processing companies. There are a whole host of other national and local and regional emphasis programs, all intended to get the agency into more workplaces, even when there are not reported incidents. There's also the SST inspection program. So the theme really is that OSHA is looking for reasons to get into your workplace proactively, not just when something bad happens, not just when there is a complaint. So it makes it all the more important that you start thinking now about what you need to do to prepare for an inspection, so you're ready, and then how you should conduct yourself in your operations when OSHA shows up. So the one statistic that I wanted to share is this one, and that is the significant increase in the number of $100,000 or greater enforcement actions. As you can see, that last year was the highest number on record. I would not be surprised if that number is just as high or even higher this year. So in addition to an increase in inspections, there is a significant increase in high dollar citations being issued as a result of those inspections. Now, just as a brief recap, sure, I know we have a lot of very sophisticated safety professionals, folks that are safety adjacent in operations or management, lawyers on this webinar. So I'm not going to spend a significant amount of time by any stretch on this slide, but just to remind folks the reasons that OSHA will typically inspect in limited number of circumstances where there is the agency has reason to believe that there is an imminent danger, they will inspect. Obviously, I think, as everyone knows, you report a fatality, you are going to be inspected. If you report a hospitalization or an amputation, there's a better than 50%, and I think with amputations, probably closer to 75% chance that you're going to be inspected. If there is a complaint that implicates one of those emphasis programs, you're likely to be inspected. You may be inspected just randomly based on your NAICS code as part of one of the national or local emphasis programs that I talked about earlier. Obviously, depending on the nature of your operations, you may be inspected based on a compliance officer driving by. The one I wanted to point out, though, it could be in part a function of my practice, my client base, but I have seen a dramatic increase in the number of follow-up inspections. And so those are inspections where you've been inspected in the past. Maybe you were not cited, but OSHA shows up to verify that either the abatement certification that you submitted is still in place, still being followed, or perhaps that letter that you submitted confirming or affirming that certain things were being done was indeed true. I've seen follow-up inspections in something as simple as a slip and fall case where no citations were issued, as well as follow-up inspections after significant enforcement actions, where OSHA came back to really dig in deep once again on issues like lockout, tagout, and machine guarding. All right, so to the meat of the program, managing inspections. What are the goals of the of an inspection from our perspective, from our client's perspective? What are the things that we try to do when we get involved? What are the things that you all should focus on if you decide to manage the inspection on your own? One is control the flow of information, right? So what does that mean? That means that OSHA is going to come in, and in many cases, you might be dealing with an aggressive compliance officer, someone who wants to see as much of your operation as possible. They want to see as many documents as possible and get them as quickly as possible. They would, if given the opportunity, they would talk to workers on the floor, maybe interrupting them while they're doing their work. They really can't focus quite as much as you'd want. They will occasionally, if not often, try to talk to managers without counsel present or even without another member of management present. They want to see certain documents very quickly. Obviously, there's the timing requirement with respect to production of the 300 logs and 300-day summaries. So you want to make sure that the right information is being provided, information that's responsive, understand what you're not obligated to provide, what you are obligated to provide and when, and make sure that they are only given access to the information, to the parts of your workplace that they are entitled to see. Second, minimize business disruption, right? So an OSHA inspection is one of those events that's going to probably throw off a lot of things. It may disrupt your operations. People are going to be nervous. They're going to be distracted, right? I've been on the floor when OSHA, they pull out their cameras and they get pretty close to the workers, and that may cause problems. Maybe they ask to see a demonstration. Maybe they ask to see a line in operation that's not in operation that day. That it's going to be disruptive. You're not required, as I'm going to talk about in a second, to do many of those things. I've shown up to inspections that were well underway, days underway, before I was retained, where OSHA had basically set up shop in a facility and had been there for, I think, close to 30 or 40 hours. We ended that. That was the last day when I arrived, was the last day that they were there. But the point was that they had no issue kind of throwing the operations into disarray because they were there. No one was saying no, and that's one of the things obviously you need to focus on and consider. Third, cast the workplace in the best light possible. And so, what does that mean? Essentially, I think you'll hear from all of us, certainly, over a cocktail, about some of the mistakes that we've seen clients make on their own, where they say that they are not doing something, or they'll whether it's acknowledging, yes, that was a late report of the hospitalization, when it turns out that the person wasn't admitted to the inpatient service, to saying that we're not doing a periodic inspection, or we're not complying with some portion of the lockout standard, when in fact they are, because they don't quite understand what they are doing correctly, or why what they are doing actually does comply with the standard. There are, to use the overused saying of there are more than one way to skin a cat. There's more than one way to do a periodic inspection, for example. And sometimes folks, in responding to the questions, are led to believe that what they're not doing or what they are doing is not correct, and they'll say that to OSHA, when in fact, through our knowledge of the area and the topics and the standards, we may be able to show that in fact you are doing what you're supposed to be doing. And so we're going to help put that best foot forward and marshal the evidence to demonstrate that to OSHA. And then last but not least, identify potential problems early, whether that's something as simple as installing a gate, fixing a railing, unblocking an eye wash station to something far more complex, like redesigning and redeploying a training program, getting people trained, changing the materials, revising your procedures. Those are things that, particularly when it appears that you're going to be cited, you may as well fix them. You really have an obligation to fix them as soon as possible. And you can gain important credit with the agency, both in the form of potentially a reduced fine, but in some cases, avoiding getting cited early and changing the perception of the area office, of the inspector, by demonstrating your commitment to getting things right. So as I said before, particularly talking about the disruptive aspects of inspections, we always, it's kind of part of our, I think, of our mantra, this section of the act that we like to quote, and sometimes have to quote back to compliance officers, and that is that OSHA may inspect, and you look at the underlined words, may inspect at reasonable times, any workplace during regular working hours, and at other reasonable times within such reasonable limits and in a reasonable manner. The word reasonable is doing a lot of work there. It appears 4 times in addition to the word regular. So taking that part first, like regular working hours, if OSHA says that they want to come back at a different time to see a process or see a task being performed, but maybe that's not when you do it. You don't obviously have to open early or stay late to accommodate a compliance officer. And in as far as the reasonable times and particularly the reasonable manner and limits, that does, again, the word does a lot of work, and so you can use it because there are a lot of things that I've had compliance officers ask my clients that are not reasonable. And that example I gave earlier, oh, hey, I see that line number 3 is down today. I would really like to see how you do, X task on line 3. Well, that is not reasonable for you to have to restart a line that you were not planning to operate just because OSHA has asked you to do it. Now, there may be considerations that come into play. The compliance officer says that they won't come back on a second day if you do it. That maybe then you reconsider that. But do you have the right people there? Are the folks that would be running it the ones that are familiar with that line? Or is it going to create a hazard to maybe it won't be operated as safely or as efficiently? Are the people that are there trained? Are they the ones that you want to demonstrate something? There are a lot of considerations to go into it. And as I often tell people, many of these decisions, there is no right answer, or these questions, there is no right answer necessarily. It's kind of bringing that judgment to bear that you have from managing past inspections, evaluating the attitude and demeanor of the compliance officer, and making those decisions on the fly. But if you kind of use this section of the act as your North Star, so to speak, as far as, is this reasonable? Is what they are asking me reasonable? Is this something that we really need to do? And so we keep coming back to that consideration to help manage inspections and keep OSHA on point. So what rights does the agency have, right? We're going to talk about agency rights, the rights of your workers, as well as you as the employer, the rights that your organization has. So OSHA has the right to inspect workplaces if they have probable cause. And Mark will probably talk about probable cause a little bit later, because there are different things that can give the agency probable cause, right? Whether that's a reported incident, whether that's a complaint that relates to an emphasis program. They have the right to expand inspections if they observe violations in plain view. They are not required to give, as everybody knows, there is no requirement to provide advance notice. In fact, it can be a crime for the agency to do that. It doesn't mean that you can't request it, right? I have been able to do that in certain instances where I have a relationship with the area office. We've worked with them on issues in the past, and we report a fatality or an amputation and let them know that we are going to be representing the employer if in fact the employer has asked us to be there. And we present it as a courtesy. Look, we are going to be there. We don't want your compliance officer to have to wait 75 or 90 minutes. So if you want to let us know when you're coming, we will plan to meet your COSHA there. They don't always take me up on that offer, but it has happened from time to time. It usually is something like, we're on our way now and we'll see you there in 75 minutes, something like that. The agency has the right to collect physical evidence, take samples, to take photographs, to request documents, and they have the right to conduct interviews. You're going to hear a good bit more about the types of interviews and how they can conduct them, whether it's private interviews with employees or attended interviews by representative management for those interviews that are done of supervisory employees. What about your employees? As I'm sure many of you know, employees have a right to file a complaint and a right then related to that to not be discriminated against or retaliated against. We always emphasize that when we are talking to employees as part of our investigations or preparing them for their interviews. My view is that I want them to hear from me the same things that they're going to hear from the agency. And your employees, although it's rare, they have a right to participate in all aspects of the inspection. Employees can attend the opening conference. They can participate in the walk around. As I said earlier, employees have a private right to be interviewed. It is the employee's right. They have a right to participate and attend closing conferences as well as informal settlement conferences. And they do have a right to access inspection records. Now, as far as your rights, and this will be a big part of our program today, as I've already emphasized, you have a right to a reasonable inspection at reasonable times. You do have the right to demand a warrant in order to commence the inspection. We'll talk also about that in a second. It's something that we rarely recommend exercising, but there may be instances where it is appropriate. You have a right to an opening conference, and as you'll hear from us both today and anytime you talk to us, it is probably, if not the most important part of the inspection, certainly one of the most important parts. And so you should absolutely positively always exercise that right for the reasons that we're going to go over. You have a right to not only access, but receive a copy of the complaint if it is a complaint-based inspection. And typically, if not in every case, the compliance officer will come with multiple copies of that complaint, hand them out during the opening conference so it can be reviewed together. The complaint will not show the name of the individual who made it, nor should you ask that. You have a right to protect trade secrets or confidential business information. We do that when we produce documents with labels on the documents, as well as language in the letter that accompanies the documents to make clear. And it really facilitates the exercise of those rights in the event that a FOIA request is made, because those documents will have already been identified ahead of time as from our perspective, exempt from production in response to a FOIA request. You have a right to participate in all management interviews. That is something that we very, very much recommend that you do. Never waive, always take advantage of that. Whether that's my preference and recommendation is to have counsel involved, but at a minimum, if not, to have another manager in there who's listening closely, taking notes and watching for anything that appears to be inappropriate or unfair being done by the compliance officer. And at the end of the inspection, you have a right to participate in the closing conference where the compliance officer will review the citations that they intend to recommend to their boss, who's typically the assistant area director, when in reality, by that point, they have decided what they're going to issue. Still an opportunity to potentially change their mind in limited circumstances, as we'll discuss. But so you have a right to that, and you should insist on that right as well. It's not always adhered to by the agency. It's not at all uncommon that you will get a call as that 6-month time period is about to expire. Sometimes even on the very last day, where I think it occasionally happens the compliance officer has kind of forgotten about this inspection, and they are in a rush to get the citations out. So you see that number come up in your phone, you don't pick it up. They may leave you a message, and if you don't call them back, they're just going to issue the citations. So it's a little bit of a truncated closing conference, not really what the law or the act intends, but it's unfortunately not enough to preclude the issuance of citations, but it's just something to be mindful of and watch for. And then last but not least, you have a right to challenge the citations that are issued by the agency. So with that, I'm going to turn it over to Ashley, who's going to run through the pre-inspection checklist with you all, and I will likely, you might hear me again as I jump in to add a little bit of emphasis or experience or war stories if that's helpful. But Ashley, take it away.
Thanks, Aaron. So as Aaron said, we're going to start by looking at this pre-inspection checklist. And here are some proactive ways that you can prepare for an OSHA inspection. The first one being review applicable emphasis programs and directives. And it's important to know which emphasis programs are ongoing in your area for a couple of different reasons. One is if your facility is covered by an emphasis program, OSHA could inspect your facility as part of that emphasis program. And so what this means is without any report of injury or illness, or even without an employee complaint, OSHA could still show up at your facility and perform an inspection if your NAICS code is within that emphasis program. It's also important to be aware of the emphasis programs in your region, because if you do in fact have a reportable injury or illness and OSHA comes on site to inspect, an emphasis program is an easy way for OSHA to expand the scope of their inspection from the area or piece of equipment that caused the reportable injury to other areas of the facility. So by way of example, OSHA has a national emphasis program on amputations and manufacturing industries. And so practically what this means is if OSHA's on site for an injury that was caused by an employee who may have been working at heights, once the inspector is on site and the inspector makes a determination that your facility has a manufacturing NAICS code, and during the walk-around portion of the inspection, the inspector observes what they believe to be machinery that could cause an amputation, the inspector could broaden the scope of their inspection from that area where the employee may have been working at a height greater than 4 feet to every single piece of machinery in the facility that they believe could cause an amputation. And so now, instead of only asking for your program regarding working at height, the inspector could request your lotto program and review your machine-specific procedures and even ask for lotto training records. And this brings us to another important point here on our pre-inspection checklist, which is designating the walk-around route. You know, as explained in our OSHA inspection toolkit and Con-Maciel Carey's inspection toolkit, you will want to escort the compliance officer to the area they are inspecting using the best route possible. And so when we say best route, what we really mean is the shortest route where the compliance officer does not have to pass and observe every single operation in your facility, because as Aaron mentioned, you know, whatever's in the plain view of the inspector, they can ask questions about. And so maybe, you know, it's the case that you are here in Region 5 with me, Aaron, and Mark. And here in Region 5, OSHA has a powered industrial vehicle emphasis program. And so with this in mind, as you're planning the route that you're going to take the inspector on, you may opt to not walk the compliance officer past the forklift charging station, for example. And so knowing which national and regional emphasis programs are in place can also be helpful when making the determination about which programs you're going to audit sooner rather than later. Some other key things to remember when preparing for an OSHA inspection is knowing who will be on your inspection team. And I can't emphasize making this decision before OSHA shows up, how important that is. Aaron and I were called by a client after OSHA had showed up at the client site and after, the compliance officer had began the opening conference. And so by the time Aaron and I were able to join the opening conference, there were at least 5 managers who were participating, and the inspector was taking the opportunity to ask each and every manager questions, and the managers were answering those questions. And so we will discuss, the importance of management interviews later, but these are critical conversations during the inspection process. And so before OSHA knocks on the door to perform an inspection, it's imperative to know who will participate in the opening conference, who will escort the compliance officer on the pre-designated route during the walk-around inspection. Something else to keep in mind, there is a requirement to provide the OSHA 300 logs and 300A summaries within 4 hours of the compliance officer requesting them. So it will also be important to know who's going to be responsible for gathering or, printing off the 300 logs and the 300A summaries. And then once you've kind of gone through that initial step of thinking about what management person will be present, who's going to be responsible for getting the logs, it's helpful to train your front office or whoever may have that initial interaction with the compliance officer on who they should contact, such that when that compliance officer walks through that front door and has that initial interaction, the person knows, okay, I need to call management A or person B before anything else happens with this compliance officer. And so with that, I do want to spend just a moment here refreshing everyone's recollection on the stages of the inspection process. I do know we have quite a few professionals, and we're going to go into each of these in greater detail this afternoon, but just really briefly, after the compliance officer shows up at your facility, you should insist on them conducting an opening conference. And then from any time really after that opening conference, all the way up through, the time citations are issued, OSHA can and will be requesting documents. After that opening conference, the compliance officer will then perform a walk-around inspection. And it's at this point where the compliance officer wants to see the areas of the facility that they identified as being within the scope of their inspection. I've already said this, but I think it's incredibly important, especially given, what Aaron has said about OSHA potentially setting up shop if you're not cautious. So you want to make sure that someone from the company escorts the compliance officer throughout the facility. And then the next stage is generally going to be employee interviews. And finally, OSHA has 6 months from the date that they open their inspection to close their inspection and issue citations. And so before the end of that 6 months, the compliance officer will hold a closing conference. And this closing conference is where they will tell you what they observed during the inspection and potential citations that they may be recommending. And then, of course, citations are issued. And after citations are issued, you have 15 working days from the day that you receive the citations to file a notice of contest.
And Ashley, I'd just add, I think you make a good point about accompanying the compliance officer around, and I would emphasize that that's particularly important. I know Dan's worked on some pretty significant inspections where monitoring takes place. And we had one client that came to us, and I always have to emphasize, after the citations were issued, and they had left the compliance officer unsupervised throughout the day while the monitoring was taking place. And so the monitoring was done. Compliance officer would check in on the employees from time to time, and then apparently was wandering the facility, taking photographs, talking to people. And so, they have no hesitation to do, or some, at least some compliance officers have no hesitation to do that. And I think as a result, in that case, they found a number of issues that they would not have otherwise found. So that applies regardless of the nature of the inspection, but be particularly vigilant if you've got the compliance officer there for an extended period of time for monitoring or some other reason.
Thanks, Aaron. So now you're at the point where you've done everything on your pre-inspection checklist, but you want to know what you do when OSHA actually shows up at your facility. The first thing you're going to want to do is escort the compliance officer to a conference room. This conference room would ideally not have any documents or information on the whiteboard or bulletin board or anything, crucial laying around. For example, you would not want your compliance officer to see an internal audit of forklift operators whose certifications have expired but are still, operating forklifts. So being really mindful about what the compliance officer is going to see and be able to view while they're in the conference room. But then after you have that compliance officer in the conference room, you should not be afraid to, have them sit there and wait a few minutes until you're able to contact the folks you've identified in your pre-inspection checklist as those who will be participating in the opening conference and participating in the walk around. This is also the time where you're going to want to reach out to counsel and inform them that OSHA has arrived at the facility. And as Aaron mentioned, and as I have seen from my experience, you're going to want to reach out to counsel before you start that opening conference, just to make sure that you are getting some advice about who's going to be participating, who's going to be in the room, and, getting that initial information about the scope of the inspection. And then even though the compliance officer has not made any requests at this point, right, all you've done is shown them to the conference room. You can bet donuts to dollars that your compliance officer is going to ask for your 300 logs. So you will also want to take the opportunity to get into contact with whoever is going to be responsible for providing that OSHA 300 log and those 300A summaries. You're going to want to let them know that OSHA is there and that they can expect the request to be coming down soon. And so all of this is to say you do not have to be immediately ready for their surprise visit. It's perfectly reasonable, and I know that's a term that we're using a lot here because that's really the standard. It's perfectly reasonable to escort that compliance officer to the conference room and then inform them, hey, we need to gather the appropriate people on our team, and then we will be more than happy to conduct the opening conference. Most compliance officers are generally, pretty understanding. They are aware that their visit is a surprise and that it will take you a few minutes to, gather whoever is supposed to participate in that opening conference and reach out to counsel. So don't feel like once they show up, at that exact moment, you've got to start the opening conference. You do have some time to gather the appropriate folks and reach out to counsel. And then once you have everyone in the room, what happens at that opening conference? So after your opening conference team is in place, and when I say team, I mean the company representative who will be participating. Representative is singular on purpose because you do want to minimize the number of folks from management who are participating. So company representative who will be participating. If you have a union on site, perhaps there's a union rep who may be present. And then, after you've reached out to your counsel, maybe you guys have decided that counsel is also participating. You are ready to begin the opening conference. And so the opening conference is where the compliance officer will collect basic information about the facility, explain why they are there, and define the scope of their inspection. And so within this process, one of the first things that will happen is the compliance officer will display their credentials just so that they are who they say they are. And then the compliance officer will go into detail about the nature of their inspection. And here is where they will explain why they are inspecting, whether it's the result of a reported injury, an employee complaint, at which point they will provide you a copy of that complaint, or whether they are on site because they believe your NAICS code is a part of an emphasis program. And based on the reason for their visit, the compliance officer will also identify specific areas of the facility that they want to see. So for example, if they're inspecting a reported injury, they will request to see the specific piece of equipment that caused the injury. Whereas if they are inspecting as part of an emphasis program, the first thing they're going to do is make sure that your NICS code does in fact fall under the scope of that emphasis program. And then if, for example, it is the amputation emphasis program, the compliance officer will request to see every piece of equipment in the facility that could result in an amputation. And so depending on your facility and how it's set up, this could result in a wall-to-wall inspection of the facility. The opening conference is also generally the place where the compliance officer will request those OSHA 300 logs, and that 4-hour time clock starts running. Now, depending on your compliance officer, depending on who is participating in the opening conference and the walk around, and depending on how long that walk around takes, the compliance officer may agree that you can provide the OSHA 300 logs and 300 A's before the close of business or even the following day, but they are not required to give you that extension. And so if you have a compliance officer who is willing, to give you that extension and does agree to an extension beyond the 4 hours, you'd be well advised to confirm that understanding in writing, ideally in an email before the expiration of that 4-hour time window. Because what you don't want to happen is that the compliance officer says, oh yeah, you can give it to me, today is Thursday, get it to me by Friday. And then you give it to them on Friday. You don't want them to forget that they have given you that extension, and so they issue a citation for not producing the logs within 4 hours. And then one final quick note, I want to take this opportunity again to reemphasize the importance of keeping those opening conference participants very lean. We're going to go into greater detail about, how everything that the managers say to the compliance officer is deemed to be company knowledge, but this is one of those very initial moments where you have the opportunity to control the flow of information. And so up until this point, everything that I've said has assumed that you have consented to the OSHA inspection process and, their request for documents and information. Here in our Chicago office, we just welcome Mark Ishu, and as he stated, he has over a decade of experience with the solicitor's office. So I'm going to pause here and ask Mark to share his experience with warrants during the OSHA inspection process.
Thank you, Ashley. So what happens in general is that, when OSHA comes to your door to inspect, and, for whatever reason, you decide not to let OSHA inside for the complaint either that they've mentioned to you that has been issued by an anonymous person, or, that they're there because of a site-specific targeting, as Aaron mentioned earlier, a program that's put in place by OSHA that requires them to go to various facilities throughout the year. If you say no, I do not want you to come inspect my facility, or if you say not today, and they believe it's time is of the essence, OSHA believes time is of the essence, they will reach out to the solicitor's office where I used to work and ask the warrant coordinator, which I used to be, for to possibly get a warrant for, to do the inspection right away. And so what the solicitor will then do is evaluate whether or not there is a Fourth Amendment basis to allow for OSHA to go to a magistrate judge, a federal magistrate judge, and get a warrant. And usually it's a quick turnaround of a few days, maybe 2 days. If it's a very egregious situation, maybe even faster than that. But there's a process that the solicitor's office goes through to evaluate whether or not it should seek a warrant from a federal magistrate judge. Now, one of the common ways, as they all have mentioned earlier, both Aaron and Ashley have mentioned earlier, there are various ways in which OSHA has a right to inspect. I'll just talk about a couple of the basics. A lot of times what happens is OSHA, gets an anonymous complaint, And that complaint refers to some concept of what a national emphasis program focuses on or a local emphasis program focuses on. So as Ashley mentioned several times, there's an NEP on amputations. So the complaint relates to a machine that is not guarded properly. If that's the case, and the solicitor's office is informed that OSHA needs a warrant because the employer refuses to let them in to conduct an inspection, then very likely the solicitor's office will kind of weigh the situation, ask a lot of questions, and decide to then seek a warrant. Now, and when you get a warrant, if OSHA shows up to your door with a warrant, that's a federal order. That's like similar to what a criminal warrant is. People think about in the movies. That gives OSHA the right to conduct the inspection. But I want you to be very clear and understand that you could ask for what the warrant lays out that they have a right to inspect and limit it to what the warrant allows. So it's very important to ask for the warrant, to see what the warrant says OSHA has a right to inspect, because it's supposed to be limited to whatever the Fourth Amendment allows. So that is kind of a general idea of thinking about how to kind of manage, when for whatever reason you decide to not allow the inspection to go forward right then and there when OSHA shows up. There's a lot of other issues to talk about here. This slide kind of mentions, that if you give consent, there's no need for a warrant, right? So, think about what you're allowing them to do. If they go in with a warrant, as Aaron and Ashley mentioned, and you give them, that's specific to a machine, for example, and only covers evaluation of that machine, make sure, again, the COSHA only is able, or the compliance officer is only able to go a certain kind of route that doesn't, let them to observe other parts of the facility that could potentially have hazards, and not let them say, or not let them go beyond what that warrant allowed. So that machine specifically, to evaluate the guarding on that machine, and that's it. So don't let that, because as Aaron said, some of them are more aggressive. So they'll say, oh, how about over there? What, I want to look into, what's over there. I want to talk to that employee over there. That's not what a warrant allows, to talk to employees, to specifically, go beyond what's listed in it. So just, again, minimize what you consent to, and make sure it's very limited to whatever the warrant has laid out. I don't know, Ashley, if you want me to go on further than that.
I wonder if you could just tell us what some of the risks of, requiring OSHA to get a warrant would be from your perspective.
So that's a good question. So there are a couple things. One, some companies have a policy to always require OSHA to get a warrant. So what will happen is, in those situations where it's understood that it's a policy of the company to require OSHA to get a warrant before ever doing an inspection, any type of inspection, OSHA will get a warrant without you knowing, and then will show up to your facility with a warrant in hand. That's, so you're not going to have, the luxury of maybe the compliance officer calling you ahead of time to let you know about how they're going to be coming on site. That could be, a problem as we're going through all these kind of checklists that you want to do beforehand in preparation. That may cause you to have, be surprised and not be ready for the inspection. But that warrant, requires the inspection to go on, immediately. Because otherwise, arguably, there would be you'd be defying a court, mandated order of a magistrate judge, and you don't want to, get into those situations because there could be significant penalties if you don't comply with a federal judge. So there is that disadvantage if you have a policy, and OSHA gets an anticipatory warrant, knowing that you're going to tell them to get warrant anyway. Another thing that, I'd like to say, my experience of 10 years at the solicitor's office, has given me kind of a perspective of, understanding that there are certain employers that, may be more difficult than others. And what generally happens in those circumstances is OSHA, as well as the solicitor's office, the legal arm, gets involved early. And, if they believe you're a difficult employer that is going to circumvent their investigation unreasonably, again, not within your rights, but unreasonably, then, they may put more resources into not only seeking an anticipatory warrant so that you will be not, surprised when they show up to your door, but also even maybe going beyond, is using every tool in their tool chest to go beyond, to expand the inspection as large as possible. So as Aaron said, I think I do agree with the Conmaciel philosophy, or what Aaron has identified. You have to be very careful how much obstruction you want to engage in, and make sure you follow, the kind of framework we're laying out today. Ashley?
Yeah, thanks, Mark. And one thing Mark did say that I thought was really important that I kind of wanted to emphasize, which is, if the agency does believe you're not going to be cooperative, or if they do go, to get that anticipatory warrant, or even a warrant that you've told them that they need, you have drastically changed how the interaction occurs between your facility and the agency. So, for example, management interviews would typically take place with the compliance officer, the manager, and then, most likely counsel. However, if it is the case that you require the agency to have a warrant to interview that manager, that completely changes from, having 3 folks in the room to now you've got the solicitor involved, and maybe they are the one taking that manager interview. And so now, instead of a compliance officer, you have a lawyer asking the manager questions, and it turns much more into a deposition style or deposition format interview. And there could even potentially be a court reporter. So whereas before you had the compliance officer taking notes, now you have this very formal transcript of what the manager has said and how they have, and what knowledge that the company has. So, there are absolutely some risks involved with warrants, but I do know that we do want to talk about other parts of the inspection. Aaron, did you want to jump in?
No, I think, Mark, I just maybe if you could answer quickly, and we're going to be running past the top of the hour for a little bit. We hope you'll stick with us. If you have to jump off, I think, as everyone knows, you'll get a copy of the recording. So you'll be able to listen to this later. You'll also get a copy of the slides. So just if you have to jump off, we apologize, but you'll get to hear the rest of it if you are so inclined. The quick question I had, Mark, is, I think one of the things that I see from time to time is after you produce the 300 log and the compliance officer has had an opportunity to comb through it, they say, oh, we'd see another accident related to this piece of machinery, or we see another laceration that could have been an amputation. We're going to expand the inspection to 3 other lines or the whole facility. That's sometimes I don't want to say that it's bluffing, but it's that overeager or aggressive compliance officer. Is that, obviously there's the well-known, the Marjack case, but my view of that is it can be a relatively high threshold in terms of using the logs to expand an inspection. And I was wondering if you had any cases where that was the basis for a warrant request.
So one of the things that I would immediately think about if an OSHA area office came to me and asked me for a warrant just based on the logs, is I would first want to know what's the time frame. That is when the injury occurred. If it was 2 years ago, well beyond the 6 months kind of statute of limitations, I would and most of the time, if not all the time, I would have identified that we shouldn't be seeking a warrant on that basis, because it goes well beyond the date in which the injury occurred. Now that may not mean that the that may not mean that the machine or where the injury occurred is not, the hazard is not still there. And so I would want to know if there is anything more that the COSHO has to develop a basis of probable cause. And so if there's personal knowledge that the COSHO or the compliance officer has, then I would want to see how that would kind of build a case for probable cause. But in and of itself, from my standpoint, that would not be sufficient. I would probably most likely tell the compliance officer to start interviewing individuals to get more of a basis for probable cause, and possibly see if they could add, we could add their affidavit to, any warrant that we would be seeking in front of, before a federal magistrate judge. So in other words, I have to develop a personal, a kind of a package of personal knowledge, or in the alternative, a basis, an unprogrammed basis. And what I mean by unprogrammed inspection basis, I mean what we had been referring to before, which are the NEP, LEPs that specifically talk about those hazards, those types of hazards. And that may give me more data and basis to say that we have enough sufficient probable cause to go in and ask for a warrant. But I want to stress that, in and of itself, a log would not be sufficient for me as the warrant coordinator. And it's because the procedures don't establish we had talked about the field operations manual as being very important and being familiar with it, because it really lays out specifically the criteria warranting an inspection. And OSHA must follow their own procedures. If they don't follow their own procedures, they shouldn't be seeking a warrant, period. One of the things that is very critical for any solicitor's office engaging with OSHA on a warrant is that we never want to make a mistake and pull the wool over the eyes of the magistrate judge, because that creates a bad reputation. And we do not want, in my old, role, I did not want ever to create an impression that we're circumventing, the Constitution, the Fourth Amendment, to gain an unfair advantage and kind of pull the wool over the eyes of the magistrate, judge, to get what we needed in that moment. So it's really, critical to follow the procedures and show the magistrate judge we're following the procedures, and that by following the procedures, we developed a specific set of facts to justify probable cause. So, that, I don't know if that answers fully your question, Aaron, but that's how I would proceed within that framework.
Yes, no, that is very helpful. Ashley, I'll turn it back to you. I know you got another slide or two, and then hand it off to Dan.
Thanks, guys. So I know that we have covered a lot of information on the opening conference. So before I turn it over to Dan, let's just do a quick recap. One of the first things that's important to remember is that you insist on the opening conference, because this is your opportunity to learn the basis for the OSHA inspection. And so by learning the basis, the inspector will also explain to you the scope of their inspection. And this may be your opportunity to kind of negotiate the scope of that inspection. We've spent some time talking about checklists, so it's important to be prepared for an OSHA visit by knowing, potentially what conference room you will escort the compliance officer to when they arrive, all the way down to who will be participating in that opening conference, who will be participating in that walk around, what potential routes there might be for you to take the compliance officer on, depending on the nature of the complaint. Have an established document protocol so that, for things that are time sensitive, like those OSHA 300 logs, exactly who you're asking for, where they are, that the printer is going to be working, and you're able to produce those logs within the 4-hour time frame. Otherwise, one of the initial goals that we talked about at the very beginning of the presentation was, controlling the flow of information and putting your best foot forward. And so that document protocol should address, what levels of review are going to be taken for each document that OSHA requests before you provide that document to the compliance officer. Another note or important recap, you can also arrange for daily closeout meetings. So even though that closing conference does not occur until the end of the inspection, at the conclusion of each interaction with the compliance officer, you can have sort of a mini closeout where you ask the compliance officer if they've identified any areas for concern or things that they would like you to repair sooner rather than later. I believe Aaron mentioned, you have an opportunity to engineer goodwill with the compliance officer and with the agency. And so by asking if they've identified any areas for concern, maybe it is the case that it's a small fix, unblocking an eye wash or something simple like that. And so you can certainly take those small proactive steps to let the agency know that you are listening and you are concerned and you are very much so invested in your employee safety. And then just a final recap, to be on the lookout for inspection creep, that inspector that slowly but surely is broadening the scope of their inspection by asking about areas that were not originally identified or asking to speak to employees that don't work in areas that were identified as being a part of, that inspection or the information that the compliance officer identified was relevant during that opening conference. And so with that, I will turn it over to Dan to talk about document production.
Thanks, Ashley. Yeah, so we have a few slides to get through, and I'll do my best to keep this brief and provide you all with the pertinent information you need. Moving on to the document production piece here. Now, this is a little bit of a kind of rolling production. There's, oftentimes an inspector is going to be asking for documents as you're going through the walk-around inspection. We do not advise that you just print out documents and provide them to an inspector on the spot, right? Insist on having a written request for documents from that inspector and have some protocols in place to make sure that everyone knows how to handle that document production process. You want to control the information that is being shared with the agency. So managing that process and having those protocols in place is really important from the get-go, and having those in place even before an inspection starts, right? And training for management on how to control that process. And we talked a little bit at the beginning of having those people that are kind of designated for individual roles, one being the document production process. Everything should funnel through that person. So again, insist on a written document request. For those of you perhaps in some of the state plans, California, for example, you have that nice document request form that OSHA usually fills out and provides to you at some point during the inspection. There's no, timeline per se that you're required to provide the documents by. And, if it's going to take you a little longer to get them documents and information, just be transparent, have a conversation with the inspector about the timeline in which you can provide those documents. Don't take forever, but if you need a little bit more time, that's certainly okay. And we've never really had too much pushback in those requests for an extension. And they usually give you at least about a week in general. The only exception being the OSHA injury and illness record keeping forms. Per the regulations, you need to provide those to an inspector within 4 hours of the request. So typically, once an inspection is opened and an inspector's on site, we want to see those injury and illness records right away so we can review them, kind of identify any potential issues early, because those are the first initial set of documents that are going to need to be provided to the inspector basically while they're on site, right? So the next bullet here about voluntary versus a subpoena in the document production process. Typically, this is done on a voluntary basis. They issue you the kind of more informal document request, whether that's by email or one of the forms that they issue. The other option is OSHA can issue a subpoena, and that has the full force of law, and you are required to comply with that subpoena. OSHA did issue an interim rule recently, kind of clarifying the subpoena process when it's used and how employers can contest those, just for more clarity for both the agency and the regulated community. We have seen a little bit of an uptick in subpoenas being issued, especially in those cases involving, significant injuries, catastrophes, fatalities, where OSHA wants to have a little bit more force and the letter of the law behind those requests that are issued to the employer. So there's also the potential, right? If you completely ignore a request that is issued on a voluntary basis, or you push back and OSHA feels that's something that they need to complete their inspection, a subpoena could be issued in those cases as well. So generally, when these document requests come out, you want to respond to the documents that are requested. Of course, you want to look at exactly what is requested. If it's kind of outside the scope of the inspection and it's asking for extraneous information that really has nothing to do with either an incident, the complaint, something along those lines, it's worth having a conversation with OSHA about that and perhaps pushing back a little bit in some instances. And this is really a judgment call. But the last thing we want to do is volunteering information, right? So we don't want you to provide more information than what's requested. The only exception there being with, if more information is going to be helpful for you, the issues that they're investigating. Say we want training information about powered industrial truck operations, and you have your general training program that's done, but you also do kind of monthly or perhaps even weekly toolbox talks. If those toolbox talks are helpful and they're relevant to your training, that's something that you might want to provide as well to kind of really bolster the strength of your program, right? So looking at the document request, thinking about it critically, what's within the scope of the inspection, what responsive documents do we have? Is there anything else that may be helpful based on the issues that are being inspected and looked at? And then we can kind of think strategically about what we're going to respond. And the last part here, we can go on to the next slide, but you want to review, of course, for responsiveness, but also whether anything is privileged or confidential business information. So we want to maintain, like I said at the beginning here, you want someone that is managing this document production process from the start, controlling that flow of information. So keeping a document control log, identifying what documents have been provided, when, who's assigned to do that, whether they are trade secret or confidential business information. You want to mark those directly on the documents that are provided. So it's very clear to OSHA that this is confidential business information. It shouldn't be shared in the event of a FOIA request or a Public Records Act request. That's really kind of the basis here. And the point of this slide is make sure that you're organized and you know what information is being provided to the agency. Okay, moving on to the walk around inspection portion. And one other thing to touch on with the document production piece, that, like I said, kind of at the start, there may be more document requests subsequent to that initial document request via email, another form. They may need additional information to follow up on their inspection. So don't be surprised if you get 1, 2, or maybe even 3 requests for documents or information throughout this inspection process. And that may happen, during the walk around, after a month or 2 after. It can be a rolling process, but it's typically initiated right at the start of the inspection, shortly after the walk around. So now moving on to the walk around inspection, we've had a lot of discussion about the scope, and really the walk around inspection is dependent on the scope of why they're there and the purpose of the inspection. So if they're there for an employee complaint about a specific piece of equipment, that's really all that the inspector should be looking at. So that's why we stress that it is important that you have that conversation at the opening conference about the scope of the inspection, and you can identify where the inspector needs to go, how to get them there without perhaps walking them through the entire facility, where that plain view doctrine may come into play, and provide opportunities for them to expand the inspection. But having that discussion up front is really important for these purposes, so you can control that walk around inspection. Some other pieces here to really keep in mind. An employee representative is permitted to accompany the inspector. So that can be an employee, it can be a manager, and we do have the union walk around rule that's being discussed by OSHA right now, which would basically allow union representatives in a non-union workplace to participate in an OSHA inspection. That's something that we're monitoring very closely. And some other kind of tips for you to keep in mind as you're going through this walk around inspection. The inspector is going to be taking notes, perhaps taking photos. We recommend taking side-by-side images and kind of documenting and taking your own notes of what the issues are and what they're looking at during that walk around inspection. And the same thing can go for sampling as well. You want to act professionally, but make sure that you're protecting your rights. Okay. So having those conversations, asking questions is perfectly acceptable. That's normal, and it's almost expected, right? So you can fix the hazards that are identified, or we should say fix the alleged hazards identified by an inspector, but be sure that you're not admitting to a violation or saying, yeah, I understand that's our bad. That shouldn't be like that or anything like that. Just fix the alleged hazard and don't say anything by way of an admission, because certainly if you're management, that knowledge is imputed to the employer, those statements, it's going to be considered an admission, right? And then finally, you want to make sure that the inspector is following your safety rules, anything by way of PPE or any other safety rules that you have at the facility. And that's something that you can talk about during the opening conference, and just making sure that they're following them as you walk around the facility. The same thing can be said for COVID. That's not really too much of an issue anymore, except perhaps out in some of the jurisdictions on the West Coast.
I think, Dan, I left that in there just because I think it was a good illustration. We had OSHA show up a couple of years ago. I think right around the time the agency was issuing the vaccine mandate, and one of our clients had a requirement that you could not enter the facility unless you presented proof of vaccination, proof of a negative test within 72 hours, or a COVID infection within the last 90 days. And the compliance officer had none of those, and we denied them entry. And they couldn't say anything about it. They had sent another compliance officer who met the criteria. So even something like that, if that's your rule, whatever your rule is, like Dan said, PPE, watch a video, whatever, you can and should insist on it.
Yep. Yeah. Great point, Aaron. Appreciate that. All right. So moving on to the next slide. This is just some tips for you all to consider when walking through the facility with the inspector. Make sure that you're escorting them everywhere without exception, right? You don't want to let an inspector have the floor to themselves to walk wherever they're going and do whatever they want. Make sure that you're there with the inspector at all times and gather some information, like I said, about the focus of the inspection, control that flow of information, and make sure that they're following your safety rules. If there is any sampling going on, we've had this come up certainly in the noise monitoring sector, air sampling. Ask for the notice of sampling and make sure that you have an understanding of why exactly that's being done. And if there's a possibility you can conduct that side-by-side sampling, we suggest doing so. Like I said before, you want to take some detailed notes so you can have that debrief with the larger team and perhaps in-house counsel, outside counsel about the inspection, what the inspector was focusing on, questions that may have been asked, photos, videos, anything that was taken during the walk around. And then finally, have a daily closeout meeting with that inspector, and you can ask about any concerns, ask about the interviews, and tasks for the next visit if they're coming back. You want to do that, both with the inspector and then separately with any management or employees that may have participated in that inspection. The next slide, we're going to talk about OSHA inspection interviews, both employee and management interviews. So to the extent that you can arrange those interviews in advance, we suggest doing so, right? And there's benefits for taking this approach, and that's you having the opportunity to explain to the employee or management what their rights are in an OSHA inspection, and also preparing them perhaps because you already have some basis, some knowledge of what the topics may be in the inspection. You're going to want to pre-select an office or a conference room if possible. I saw earlier in the presentation there was a question about construction sites. What do you do then? Well, if you have a trailer, perhaps where people can be interviewed, do that, or somewhere away from the active construction site would be preferable, right? Keeping them away from any active work tasks that are being performed, and just providing a separate area for the employee or the manager to have that interview with OSHA. So there's kind of, I don't want to say it's an interview, but there's circumstances, right, where an inspector is going to just stop and talk to employees. And this isn't necessarily a formal interview. It's just to stop, ask questions about perhaps how they perform certain tasks. And what we like to go by is this 5-minute rule. If it's going to be more than 5 minutes, request that be done separately later as a more formal interview, right? If it's a really substantive conversation that they're looking to have, that should be in the form of an interview, not kind of the stop and talk, asking questions. And that's really something that you got to be aware of and kind of on the lookout for. And you being close and escorting the inspector around, you should know exactly what they're asking, what the responses are from those employees. But again, if we're getting into a lot of substantive detail, and it's looking like this is going to be a more formal interview, and also if it's really disrupting the workflow and your work activities and on the job, simply request that this be set up later, and you can have that set up as a more formal interview. And again, that gives you the opportunity to present to the employee their rights, refresh them on certain topics, and prepare them for the interview. Most of these inspection interviews are going to be voluntary, but again, we want to control the interviews to the extent possible. So if you can schedule those, be it later in the day, on site, or perhaps even by phone, that's great. There's certain instances in which OSHA will use a subpoena for an interview. And again, that's similar to the same subpoena that they'll issue for document requests, right? It has the same force of law, and it requires someone to appear and testify under oath. So typically, these are going to be in the form of the voluntary interviews, and you have more control. You can have a conversation with OSHA about who is selected for the interviews in many cases, and kind of limit the amount of people who are going to be speaking to them, and have the ability to prepare them. So for non-supervisor interviews, and this kind of gets into the rights here. So typically OSHA demands privacy for hourly employee interviews, and they rely on their field operations manual experience, but employees do have rights. The right to a private interview belongs to the employee. So they can request to have a representative present with them, be that a union representative, management representative. It is their right to consent to a private interview. And you'll get a lot of pushback often from OSHA that, oh, this has to be a private interview, that's in our policy. That's not necessarily true. If the employee insists on having a representative present with them, they have that right. One question that often comes up, and we get a lot of questions on this from our clients is, well, what about a lead? Is a lead considered an employee or a supervisor or a manager, right? And this gets into really fact specific details that we'd have to walk through with you kind of on the spot. And this really gets into, well, and on the next slide, we'll talk about supervisory interviews where you as an employer have the right to sit in on that interview. That is not OSHA's right for a private interview of management. And we recommend always having, typically at that stage, counsel present, in-house counsel, outside counsel, but at least some representative from the company sitting in on a management interview. So a lead, where you may have some supervisory role, but it's really an hourly employee, doesn't have the ability to hire or fire anyone, set wages, set schedules, things like that. It's a really fact-specific inquiry that we have to discuss on the spot and decide whether this person is going to be considered management and someone that will, impute knowledge to you as an employer, and we can sit in on that interview or not. And some final tips here: don't coerce or intimidate employees. Don't discriminate against employees for participating in the inspection. That is their right to participate or not. They don't have to participate in an OSHA interview if they don't want to. We typically like to see cooperation, because in the event that OSHA does want to interview that employee, they can go get a subpoena, right? And then finally, prepare them before their interviews. And this gets back to having some control over the interview process and being able to explain those employee rights and perhaps review some of the topics that may be discussed in the interview and refresh their recollection on things like their training, perhaps the applicable policies that are at play. So it's important maybe to have that conversation with the employee ahead of time before their interview. All right, we're getting into the last few slides here. Supervisory employee interviews, I've stressed this a few times. The supervisor and management's knowledge is imputed to the employer. So anything that they say, right, can and used, will be used against you in some way. So we don't suggest there be any impromptu management interviews. And this is kind of a mistake that some employers make, where a manager may think, oh, I have the inspection under control. I'm just going to sit down with the inspector, handle this, and we'll get them out of our workplace immediately. And then, you don't remember exactly what was said, and it can come back to bite you in the long run, perhaps. So having a secondary set of ears and eyes, perhaps, to sit in on that interview, listen to what was talked about, listen to the responses, is really important. And having the control and ability to set that up from the get-go is really important, and we can't stress that enough. So the right, again, belongs to the employer, the right to sit in on that interview. It's not the witness. And then same thing with management witnesses as with employees. You want to prepare all management witnesses for these interviews and go through things in a little bit more detail, perhaps. Applicable policies, training, discipline, audits, everything that may be coming up in this interview, you want to review with them ahead of time. So the next slide, preparing for employee interviews, or I should say preparing employees for these interviews. There's a few things that we want to do: explain witness rights, give some interview tips, and review the substantive issues that are going to be discussed. And we don't need to go over this slide in too much detail, but these are really the witness rights and interview tips that you really want to stress to them beforehand. Remind them it's a voluntary interview. You write to a reasonable schedule, and you don't have to do it on OSHA's time. You have the right to be represented, the right not to be video recorded, and you have the right to not sign, write, or draw any diagrams, sign a statement, write out a statement, or anything like that. And we don't recommend employees to sign, notes that are written by an inspector often. It's entirely their right to do so if they want to. So again, you don't coerce them, but reminding them that, well, if it's notes of what you said, is that really what your statement is? And, oftentimes it's not an exact transcription of what an employee is saying, right? The right to examine documents. If any policies, documents, photos are being referenced during an interview, make sure that they review those documents or any photos that are shared. And if the inspector is referencing them in passing, they have the right to ask to see them, just so they're on the same page and everyone knows what is being discussed. They have the right to take a break at any time. And then finally, always tell the truth. That's the most important rule. We want our employees to tell the truth. There's no coercion, no lying, and listen carefully and answer the questions that is asked. So some short, concise answers is really what we're looking for. We don't need to volunteer any information or try to provide an answer that's satisfactory or pleasing to an inspector. Just listen to the question carefully and answer that question that's asked. And stick to the facts. Only answer questions that you have factual knowledge about. You don't have to guess or speculate, or like I said, make an answer up that is satisfactory or pleasing to an inspector. Just speak to what's within your knowledge. If there's a question that you don't know the answer to, it's fine to say, I don't know, or I can follow up on that, or I don't remember. No silence is awkward. So if an employee needs or a manager needs time to think about an answer, that's fine. Likewise, if the inspector is just sitting there in silence and waiting for you to speak more, and you've already said your piece and answered the question, that's fine. You don't need to fill the awkward silence and just start talking for the sake of talking. And then the last piece, don't let the inspector answer for you. A lot of times you'll see inspectors try to regurgitate an answer to you that may or may not be what you said. If what the inspector has repeated back to you is factually inaccurate or modified in some way, feel free to correct them. All right, now on to the last piece. We're at the final two slides here, the closing conference. Now, this is held at the close of the inspection, and it might occur weeks after the on-site inspection or even months. This is where the COSHA will either set up a telephone conference or be on site. They're going to explain the post-citation rights and communicate the findings of the inspection. So they'll identify any standards that were allegedly violated, the basis for those alleged violations, and possible abatement and abatement dates. They're usually not going to share the classification or penalty amount at this time. And also, a lot of times these are preliminary findings that need to be addressed with either the district manager or the area director to get final approval and sign off on these alleged violations. So that's what you'll get during this closing conference, is kind of the overview of any potential violations that may be issued and your rights, the post-citation rights and the appeal rights that you have as an employer. So on the last slide here, this is some tips about how to handle that closing conference. And typically this is just a presentation by the inspector about, like I said, the alleged violations, the basis for those violations, and the decision has already been made. And this is what's going to be presented to the area director. In a lot of cases that may involve significant injuries, fatalities, catastrophes. They've already had this conversation. The area director and perhaps regional administrator have already been involved. And those are the citations that may be issued. But if there's any obvious errors or, incorrections in what they're saying, feel free to correct those errors. But this isn't the stage where we're going to get into an argument or presenting our all-out defenses to the alleged citations, right? You can identify any alleged violations that have already been corrected. You can also request some time to offer additional information if there's supplemental information or documents that may be helpful in addressing some of the concerns or the alleged hazards. That's something that we can consider providing subsequent to the closing conference here. Make sure that you're not offering any commitments about abatement what exactly you're going to do. The abatement is up to you as an employer on how to fix an alleged hazard. So OSHA can't tell you exactly how you as an employer are required to abate any alleged hazard. So that's why we can't stress enough, don't make any commitments about what exactly you're going to do, because that could be held against you and something that you're expected to do going forward. You can have a discussion about citation classifications and penalties to the extent that they know at that point. Oftentimes they don't, but also just take detailed notes, listen to what the inspector has to say, and we can debrief after that. And that's where we come up with the inspection or the citation defense strategy and next steps moving forward. And you can ask about the anticipated timeline of when the citations are going to be issued, and also be very clear about who the citations should be sent to, both the correct address and the addressee. So we're making sure that we get those citations in the hands of the correct person, because as you all know, we have a pretty strict timeline in which we need to file that notice of contest or set up that or appeal in some state plan states and set up that informal conference. So that's the final piece on the closing conference part. If you all have any questions, I know there's a lot in the chat here, and I think maybe we'll go through these one at a time here and address them, but also feel free to reach out to us after the presentation here. So Aaron, I'll turn it back over to you to kind of take us home, and then.
Thank you, Dan. Good job, everyone. This slide, you can see our webinar calendar for the year. There are still at least 6 left, and I say at least because we from time to time are known to throw in an extra one as events warrant. So if you're not registered for the whole set of programs, please do. We also, if you have any mining or MSHA operations, we have a MSHA webinar series led by our partner Nick Scala. We have 4 different blogs that the firm publishes. Hopefully you're aware of all of them. Lots of good information in there. If you have not heard the news that we've been celebrating, last week we were honored to be selected once again for the 2nd year in a row as one of only 3 firms recognized by Chambers as a Band 1 national OSHA practice. We're the only boutique firm in that list of 3. A number of our attorneys are also individually recognized by Chambers, which was also a great honor. As Dan said, we are happy to stick around and answer some questions. I'll start answering a few of them, and then we'll kind of just go through here and see if there are a few more that Dan, Ashley, or Mark can answer. One person asked, what about videos taken by the compliance officer? It's generally the same rule as photographs in terms of you can shoot side-by-side videos. That said, in my view, a video can be, depending on how it's done, more disruptive or distracting than just a quick camera snap. I think I even was alluding to one incident where I concluded that the compliance officer was actually unnerving the employee, causing her to make mistakes. At which point, I worked with my client to promptly shut the line down because we felt that it was creating a hazard, in part given the way that the compliance officer was taking the video, kind of standing there, arm extended, et cetera. So, every situation is different. They do have a right to take videos, but you have a right to have input on how those videos are taken, in my view. A couple people asked about employee interviews, specifically worker or non-supervisory interviews. Can those employees refuse to be interviewed? The answer is yes. Should you advise them to refuse? I certainly would say no. When any of us prepare people, when we talk about preparing, it's really orienting an hourly employee for the interview, meaning going over their rights and their responsibilities, letting them know that they do not have to be interviewed. But I always make clear I'm not telling them that they should refuse, just that it is their choice. If a subpoena is issued, obviously that's another story, and then you'd either have to move to quash the subpoena or try to negotiate a compromise. But once somebody is subpoenaed, then they would have to sit for their interview unless some relief is obtained from that subpoena. One person asked a good question. We talk about stop and chat interviews and that it can be difficult, if not impossible, to prep somebody because a lot of interviews take place, only about 5 to 10 minutes on the line while the compliance officer is walking through. In many cases, we do consent to that. We allow that to take place, but I'm not opposed to, and from time to time, we can discuss that with the compliance officer in advance, particularly if the operations don't allow it. And I honestly think in many cases that is the case, meaning no, that person cannot step away from the control panel, from the machine, from the HMI, from the forklift, et cetera, because they are potentially at risk because they're not paying attention to their surroundings. The process is placed in jeopardy, meaning perhaps the product is ruined, something goes wrong with production. Maybe you're not getting orders out if they are an order selector or a forklift operator. So in those cases, I would discuss in advance before you're out on the floor that if you identify an employee who you would like to interview, point them out to us. We will tell you their name so you can confirm that that's who is made available to you later. And then we will arrange for coverage for that person at their workstation and have them be interviewed in a private office. And in addition to impacting the process and safety, the other point is we want that individual to be able to focus and be able to pay attention, to listen carefully. Conversations on a plant floor when there's a lot of noise, perhaps people are wearing hearing protection. Perhaps the person is focused on their job. They're trying to be safe. They're trying to watch the product. That is not a recipe for success in terms of being an effective interview. And so I think it is entirely reasonable to even say we are not going to allow or consent to on the shop floor interviews. If you have questions about the procedures, we'll make those available during the interview, et cetera. You've got to use that with caution, but that is one option to take. So, Dan, or Ashley or Mark, I don't know if you all have any thoughts on that. I'm going to go through some of the other questions and try to answer those as well.
I see one question here about requests for documents and the record keeping logs that are required to be provided within 4 hours of request. And what about requests for other programs like HASCOM or Lotto programs? And that's something that we want to be able to take a look at and review prior to handing them over to OSHA. So we don't recommend providing any policies or programs on the spot to the agency during the walkthrough inspection. Make them outline and issue you that document request that lists the policies or programs that they want to see. Because if they find, say you hand them the Lotto program during the walkthrough inspection, and they start scouring through that and identify some potential gaps, that can lead them to, some additional questioning, perhaps expanding the scope of the inspection out of the gate right there during the walk around inspection. So the only documents that we recommend providing on the spot are those injury and illness record keeping logs.
Yeah, and someone followed up with, I think, a question about that. Are you required to provide others? Sometimes you get the compliance officer who says, "I insist that you give me your lockout program right now," or "I insist that you give me the machine specific procedure." Whether that's because they don't believe you actually have it. I don't know. It could be like that they need it for their questioning, and we don't set out to frustrate them at every turn or unnecessarily anger them. So it may the best solution in some of those cases may be absolutely, here's a copy of the Lotto procedure for that machine. You're free to use it during your questioning, free to take a picture of it, but we are not going to provide a copy for you to take away today, because our process is to label each document that is before it is produced with a number so we can track it. and to place a confidential business information or trade secret sticker on it or label on it, so we can prevent that it is not disclosed improperly down the line. And there's really no basis to push back on that, right? So you're giving them what they need to verify that it exists or to ask their questions, but you are protecting your rights to track and protect your documents. So that is one approach to that question. Let's see. Someone asked, can they take pictures of areas that we don't let people take pictures of? The answer essentially is yes, but what you should do before they take that picture is explain to them that area contains confidential or trade secret either information or processes, that you ask them that or any other photos of that area be marked as such, and so they know to do that. And then I would send a letter or an email after the fact confirming that, when you took photographs in these areas of these things, those are confidential areas, the processes, the product, whatever, include the appropriate language, and then they should be that should be marked or noted in the inspection file. There are a lot of questions about California, and obviously some of these issues or our advice may not apply as directly in California. We do have a separate California webinar, and if there is sufficient interest, maybe one of those bonus programs will be managing inspections in California. So let us know if that's something that you all are interested in hearing about. I think I see the questions keep coming in. So I don't know, Dan, if Ashley or Mark, if you saw any more, if anyone wants to jump in and answer one, please do. I see one question. Is there a time limit for interviews over 2 hours at the initial interview with additional follow-up calls? There is not necessarily a time limit, but again, as I said at the start, it's a question of reasonableness. And if the issues being explored in the interview are significant and complicated, then 2 hours may be reasonable. If the compliance officer is just using it as a fishing expedition, it's not reasonable. If the employee comes out and says, I don't want to talk to this person anymore, they're just asking me all these questions that have nothing to do with the accident that happened the other day, that's I think a good time to intervene and say, we think that this interview has come to an end, or we'd ask that you move on to the next step, and if you feel the need to talk to this individual again, let us know and we'll evaluate that. A lot of what I do is not a direct no. It's more so kind of a compromised or creating the appearance of cooperation and pushing some of those more difficult discussions down the road, because they often do not follow up. Someone had asked, what do you do when they're trying to expand the scope of the inspection on the plant floor? So you've discussed where they're going to go and agreed to that during the opening. You're out there, they're wrapping that up, and then, I'd like to go see this other line or this other wing of the facility. And it can be challenging to make that decision and really evaluate right there on the floor. So my approach is to say, let's finish what we agreed that we're going to do out here. And once we're done, we'll go back to the office and we'll talk about anything else that you'd like to do. And typically, if we don't agree with that, we'll say, we've completed the portion of the inspection that we consented to at the outset. And if, once you get back to the office, talk about it with your supervisor. If you all believe that there is still a need to go see this other area, we can have that discussion at a later date. And in the majority of occasions that never happens, because they realize they don't have a right or the ability to do that.
And just to add to that, Aaron, one of the things that, I just left the solicitor's office not too long ago, just about 2 months here. So I'll tell you, the current state of personnel at OSHA, a lot of the compliance officers are brand new. If they may not know the rules very well, is what I'm trying to tell you. So to Aaron's point, they're going to go back after, getting denied, essentially from the employer to their supervisor, and their supervisor is going to tell them what their rules are and say, no, don't follow up on that. So, I think Aaron's strategy, generally speaking, not only is it a great strategy to be reasonable as much as you can in a way where you're not outright, obstructing everything, but also with the idea that, there are rules these folks need to follow, and they may not know their rules very well. So you need to put a stop to it in the best way possible.
Yeah, and so someone just commented, we are seeing a lot of new co-shows, and I would respond to that with, yes, we are too. In many cases, they accompany a more veteran compliance officer, and you get some really interesting dynamics. I think sometimes that veteran tries to show off and maybe be more aggressive than they would normally be. Sometimes and it can be even worse when the new one comes by themselves, because they just really, like Mark said, often have no idea what they're doing. They don't have a relationship with you. I mean, most of the compliance officers in Chicago I know, and they trust me, and so we're able to have pretty productive discussions. And the newer folks, we don't have that. I also saw a couple of questions about security clearance issues. That's a pretty high technical and complicated aspect. I know that we worked on inspections involving top secret clearance areas. Dan, I don't know if you're able to talk about that generally, obviously, without revealing any client confidences, but like anything, I mean, if there are extenuating circumstances, I believe we had a case where the compliance officer did not have a security clearance, and so that entry was denied based on that, and OSHA had to send somebody different at a later date. So I think the same issue would have, just like I talk about trade secret information, if there is kind of a high level security issue, top secret clearance issue with respect to photographs, my inclination, what I would do would be to deny the opportunity to take that photograph, but commit to discussing it with them further until we can iron it out. Right. I think one mistake that a lot of people make during inspections is they feel this pressure to do. We need to figure this out right now on the shop floor. Can you talk to this person? Can you go there? They've got 6 months to do the inspection. Provided it's not an imminent danger situation, which it never is in my experience, that they need to go somewhere or talk to somebody. As long as you demonstrate to them, we're not flat out forever refusing to do this or that. We just don't know that we can do this, or we don't know that this is correct right now. We commit to you that we will look into this and get back to you. And if we can make this person available, if we can give you access, if we can send you this photo, we will do that. Odds are when you approach it in that manner, they're not going to run and get that warrant, which may take 2 days, or issue that subpoena or seek to enforce that subpoena, because the judge is going to ask them what's going on. And they're going to have to tell, the lawyer for the company or the company's representative said they were willing to consider it and they were looking into it, but we didn't want to wait. So that's not a reasonable approach, in my view, for the agency to take. And so as long as you are in a dialogue with them and you're being reasonable, I think you stand in good shape of favorable outcome on issues like that.
Yeah, and OSHA's field operations manual, and almost every state plant's field operations manual has a section on security clearances and what to do if you're an establishment that has material or processes that are classified by the government as, an interest of national security or something like that. And they're supposed to arrange with the area director to make sure that any inspector going there has the appropriate security clearances. So out of the gate, that's one thing. If you are covered by kind of top secret clearance type establishments, that you check with the inspector at the beginning of that inspection that they have the appropriate clearance.
Very helpful, Dan. Yeah, it's kind of like the COVID vaccine, which hopefully is not an issue we'll ever encounter again. Someone else asked, what do we do? How do you manage if they come in for a hearing conservation program inspection, but then see forklifts and ask about forklift training, right? So that is, I think, exactly what Ashley was talking about. Here in Illinois, where there is a local emphasis program on forklifts, that gives them the right to expand their inspection. And so they can ask for records, they can ask to interview the operator. I would use that same rule, right? About you're not going to pull that person if they're, driving down an aisle to deliver a package. You don't have to have them stop and get off and stop what they're doing. You can just, confirm their name for the compliance officer and say you will make them available later when at an appropriate time. But that would be the basis to expand the inspection. If you are in a jurisdiction where there is no emphasis program regarding forklifts, provided the forklift operator was appropriately operating the forklift and not engaging in some sort of hazardous driving or violating one of the operating requirements of the PIT standard, then I would argue that there is no basis to expand, at least in the Fed OSHA system.
I'll just add a little bit to that. I do agree with you. They could upgrade because the LEP, Aaron. That said, if you're in the jurisdiction that we're, Region 5, which is Illinois, includes Illinois, and there is an inspection for something that's totally, hearing conservation, and then they see forklifts, I would say that we have to look carefully at the LEP, but I don't think the LEP says outright anything is allowed to be inspected, such that there could be an upgrade to expand that area. But I would say, because there has to be a referral. Now the compliance officer can make the referral, but there has to be a referral for something that's not operating properly in that arena. For arguably a justification to get a warrant. Now they could try to expand it if you want to work with them because it's reasonable, that's fine. But that said, if they're going to be seeking a warrant to expand it because they know there's a forklifts on site and they just saw forklifts, I don't, unless they see something wrong, maybe one of the lights are out or whatever, or something hazardous is apparent to them in the plain view framework. They don't have, in my opinion, a real strong basis to get a warrant if you decide to deny them, access to the forklift area of your facility. That's the only thing I want to add. I don't know what you think, Aaron, about that, seeing these types of things.
I think you have to, bottom line, you have to pull out the directive for that emphasis program and read it and confirm what it allows, because each emphasis program is a little bit different, and there is a section that talks about those types of referrals or expansions that Mark's talking about. And again, a lot of it is, your decision making may depend on your confidence in your forklift program, of the operator who's being observed, your relation, how's the inspection going otherwise, the demeanor of the compliance officer. I think every time where that's happened with us, it was in an inspection that was going well. The compliance officer, just said, "Oh, I just need to ask this person 2 questions," and that's all they did. On the other hand, if it was some hyper aggressive compliance officer and maybe things weren't going that well, that might be the instance where you say, well, hold on, let's hit pause. Let's, we're not refusing to cooperate totally, but we're not going to do that right now. And then pull out that directive, review it, and see, what it is that they are entitled to do based off of it. I see a question that just came in, and thanks for sticking with us and still listening and still thinking about this topic. Someone asked about the proposed change to the rule regarding who can participate in an inspection. That, as some of you all may remember, during the Obama administration, OSHA issued a letter of interpretation concluding that union representatives could be participants in inspections even when it was not a workplace represented by that union. That created a lot of controversy, and not surprisingly, that interpretation letter was withdrawn during the Trump administration. And OSHA has now taken a different tact. Rather than interpreting the rule as it exists, the agency has begun the rulemaking process to revise the rule to specifically include union representatives in that section of the standard to recognize their right or ability to participate in the rule. So we are awaiting the next step in the rulemaking process. And if OSHA is able to change the rule accordingly, then that could make it easier to have union officials or representatives participate in those inspections, depending on when that change is made and whether there's a change in party in the White House. It could be rescinded as the ergonomics rule was a number of years ago. And I would expect a legal challenge regardless to that change, but it is something that we are tracking closely. Right, I think that we have answered almost every question. This is probably one of the largest number of questions that I can recall getting. I see just real quick a question about voluntary OSHA inspections. I assume that question really refers to consenting to the inspection as opposed to insisting on a warrant, which is again typically what we do. But we consent, as we've discussed at length, to the scope that we believe to be reasonable and appropriate given the basis for the inspection. I think that really covers. I think we've covered all, and we are coming up on 2 hours. So I think even those of us that had a long lunch break scheduled probably have to get to another call or meeting. So again, we thank you for your participation. Really engaged group, great discussion, and we hope you'll join us for future webinars. And don't hesitate to give any of us a call if you have any questions. We'd be happy to help. Thank you, and have a great rest of your day and a great weekend.